Dobrý den.
Dobrý den.
And děkuji. That you invited me here today. It's my honor to be here. I'm not a practitioner, I'm not a policy maker, and I do not represent, as far as I know, Austria. But I'm happy to discuss the situation in Austria at the moment. And you have my slides translated, so maybe it's easy for you to follow. Okay, so let's try and do that. I would like to start with the context and the principles why there is a reason to proceed to sometimes constitutional reform when it comes to freedom of information. For a law to be legitimate, so for a new set of norms to be not only legal, but also legitimate, there has to be good reason. The law has to address social needs, and it has to address what the public requires from the state. So the pillars of the democratic state, at least in our countries and the ones we know with mature democracies, are as follows. It is based, the relationship of the state to the citizen is based on what we call the social contract. The citizen has given some power over to the state under the agreement that the state will act in the citizen's best interest and for the common good. So the state is expected to pursue tasks that are in the interest of the common good, and therefore this is how it derives its legitimacy to make decisions and to exercise its power. It is, of course, important that the state itself respects the law and applies it. But a law has to be also fair. Respect for human rights and fundamental freedoms, which means, of course, that laws are not simply a national matter, but also an international and a global issue. Furthermore, beyond these applications of the law, the state and its authorities have to be responsive to the public, and they are also responsible to create what we call public value. That means they are not wasteful, and they are investing in the future of the country they lead. Finally, in terms of the principles of good governance, what the state is required to do in mature democracies is to ensure the maximum participation of citizens in governance. Why are we here? Why are we discussing freedom of information and access to information? First of all, there is a global political, if you like, demand by global citizens that people have access to information, either that is information that is either generated by the state or held by the state. This demand for information and access to it is bound, of course, with further political claims about accountability and, of course, responsiveness, as I mentioned. Another factor that forces us to see the issue of access to information is the fact that our communicative environments have changed dramatically in the past 10 years. So with that come the generational experience, meaning that younger generations are cultivated in environments where information flow is free and seamless. So there is little understanding why information cannot be out there. Further factors are, of course, something that we experience more or less to differing kinds of intensity, is the global financial crisis that since 2008 have put in very under question the forms of governance, both of public authorities and of the banking system, for example, the banking sector, and the financial sector in general. This is because it has endangered social rights, earned rights, and it has brought rifts to what we call a social cohesion in many parts of the world. This is tightly related, of course, to issues of better governance. Final factor is the fact that we have seen social unrest and civil wars, even revolutions or springs across the world, and whose demand is exactly this: accountability of the state, transparency, access to information, and at the end of it all, it is about a larger part of participation of citizens in state governance. The legal requirements that our countries have signed up to derive from a series of legal documents that are not strictly national or even only European. For a start, we have the Article 19 of the Universal Declaration of Human Rights that explicitly says that it is a human right to impart and access information. We have the Lisbon Treaty, where member states are bound by freedom of information commitments. We have Article 42, the right to access to documents on the European Charter of Fundamental Rights, and Article 41, that refers to the right of citizens to good governance. These are positive rights, are rights to do something. Furthermore, we have the European Convention on Access to Official Documents, drafted by the Council of Europe. We have the Joint Declaration of the United Nations and the OSCE on protecting free media and free expression. And finally, we have the Directive of 2003 to be amended next year, the coming year, that refers to the public sector information and the reuse of public data. So this is the context within which Austria is finding itself at the crossroads of reforming its constitution and its legal framework. Because the matter of access to information is closely related to good governance, and before I start to discuss the problems in Austria, let me give you the good news first. The good news is that according to a world report about world governance indicators, Austria is consistently among the top 10% countries in the world. This means that it has run its business according to certain indicators. I have listed some of them here. Having said that, it has slipped down in the past couple of years. In any case, Austria as a system, political system and administration should rightly be proud to say that it belongs to the top 10% countries in the world in terms of voice and accountability, in terms of political stability, in terms of government effectiveness and regulatory quality, as well as control of corruption, although the latter has fallen at an all-time low at 88%, still among the top of the world, of course, since 2009. The reason I'm saying that is because even with, is to make the point that even in the best of conditions, political stability, experience in managing public affairs effectively, fairly, and so on, this question of access to information is so important and complex that it can be really hard sometimes to get it right. The bad news is that Austria is scored as the last country in the world in its performance to providing access to information for its citizens. According to the RTI international rankings, Austria is at the bottom of all countries explored. I have a list here with 10 best and 10 worst. If I find my list, that would be good. Yes. So Austria finds itself below the Dominican Republic and Uzbekistan, below Taiwan, Italian, Belgium, Jordanian. Also Germany is not doing very well. Tajikistan, Liechtenstein, and then comes Austria. The best in the world are Serbia, India, Croatia, Liberia, El Salvador, Mexico, Antigua, Azerbaijan, Ukraine, Ethiopia. Now you will say, of course, there's an issue between having the formal requirements and the practice of applying those. This is a different conference. What is the red light here for us is the fact that a country such as Austria, with all these indicators so highly developed of good governance, of wealth and prosperity, of democracy, of its role in international affairs, is ranking so low in these international rankings. I would like to take you through these indicators because I believe it's one of the few occasions where you will have the time to go through such indicators and understand the depth of what is going on. So, the right to access was scored with 2 out of maximum score of 6 for Austria. Obviously, because, I will come back to that in a minute, because there is a fundamental law provision that does not allow public servants to speak of what they see in their daily working lives. Requesting procedures is another problematic area for Austria. Let me find the most important parts because there are too many indicators here. So I am going to only refer to 4. Austria scores so low because it does not provide for public officials to provide assistance to help requesters formulate their requests or to contact and assist requesters where requests that have been made are vague, unduly broad, or otherwise need clarification. So you see, there's an expectation that the state actively supports the citizens in accessing information. Another thing that Austria doesn't do is to require from public officials to provide assistance to requesters who require it because of special needs, for example, or because they are illiterate or disabled. Another point is that Austria does not provide for requesters to be provided with a receipt or acknowledgement upon lodging a request within a reasonable time frame. Reasonable time frame here is understood as 5 working days. The next area is exceptions, and the list is very long, I'm afraid. Very, very long. There are 49 points. So I'm not going to go through them, but only I will highlight a couple. One of the main critiques is that the exceptions to the right of access, there's a requirement that the exceptions to the right of access are consistent with international standards. So permissible exceptions are, as we heard, national security, international relations, public health and safety, the prevention, investigation, and prosecution of legal wrongs, privacy, legitimate commercial and other economic interests, management of the economy, fair administration of justice, a legal advice privilege, conservation of the environment, and legitimate policy making and other operations of public authorities. So the Austrian law says only the following: information shall be given only or to an extent which does not substantially impair compliance with the other duties of the administration. Professional organizations are only obliged to give information to its members, and only to the extent as this does not prevent proper compliance with the statutory duties. Such information shall not be given if it is obviously requested in a frivolous way. It is very vague. It is not specific. Therefore, it's very problematic. Another area is that there is no harm test that is applied to all exceptions. So when the public authorities make decisions not to provide information, there is no such thing as the harm test to show, for example, the risk or actual harm to a protected interest that might be refused. Another area is that there is there's a requirement that there's a mandatory public interest override, so that information must be disclosed where this is in the overall public interest, even if this may harm a protected interest, and there's no provision in the law for that. Another area are the area of appeals, also with various indicators that the Austrian law does not provide very much. Then it's the area of sanctions. And there is no provision, for example, to redress the problem of public authorities which systematically fail to disclose information or underperform. This is another interesting area. Furthermore, there are no sanctions that can be imposed on those who willfully act to undermine the right to information, including through the unauthorized destruction of information. Another very interesting point I find is that the international standards on information access require that there are legal protections against imposing sanctions on those who, in good faith, release information which discloses wrongdoings. In other words, whistleblowers. And again, the Austrian law does not provide such protection. Final point is the promotional measures area. And the expectations are that public authorities are required to appoint dedicated officials, and Austria does not have them. They are required that public awareness raising efforts are taken, and there's no provision in law for that, to inform citizens of their right to access information. And another point is that public authorities are required to report annually on the actions they have taken to implement their disclosure obligations. This includes statistics on requests received and how they were dealt with. And again, the law in Austria does not provide for that. As you can see, the right to access to information is much more complex than simply responding, it's not simply, figure of speech, responding to citizens. It involves a whole political culture and a range of framework that includes both responsiveness, but also proactiveness on behalf of the state. So in Austria, we have what we call the Amtsschweigepflicht, which means the duty to secrecy for all civil servants. This is written in the Constitution, and it says, all functionaries entrusted with federal, Länder, and municipal administrative duties are pledged to secrecy about all facts of which they obtained knowledge exclusively from their official activity. There is no information officer, as I said, and there's, of course, a perceived conflict between the freedom of information and protection of personal data. And another tension is the fact that there are administrative tensions at the level of Länder or Bundesland or municipalities. What does the public think about that? the right to access to information has been on the headlines in the past couple of years. In Austria, we have new NGOs that have formed to put pressure on the state to move forward with a draft law and constitutional change. For example, there is a new NGO for transparency that was founded on September 28th, which was the International Day for the Right to Know. And they have created a portal, it's called Frag den Staat, Ask the State, to encourage people to submit questions to the state, requests for information. They have then taken this, the response of the state, and they have created a blacklist of prizes, I'm afraid. Who is the worst kind of authority that gives the worst reasons for not giving information? One has to see that, of course, in the context of creating publicity and public awareness, so many kind of communicative tricks will be employed. Nevertheless, it has gained a lot of supporters, as you can see, over 10,000 at the time of writing, and it has earned Concordia Prize for Press Freedom. Also, the press is very much critical of the current state of affairs in Austria. The arguments, of course, for a change in law are about the prevention of corruption, not in the sense of avoiding corruption, but in a sense of intervening earlier. Another one is the argument that data, open data, create ideas, help create ideas. So you see, it is a positive kind of approach to open data. And there's another dimension here, which is the demand for raw data by governments to be made available, because the argument is we cannot make decisions a priori which documents and which data will be useful in the future. So this is the international and the national legal and social climate, and now this is the response of the Austrian authorities. They have put together a proposal, a law proposal. It will require reform of the constitution. This proposal is to change the paradigm exactly from one of duty to silence and secrecy to one to duty to provide information. So this proposal is based on the principle of open government and on the duty to information. Furthermore, the proposal pays attention to the need for the law to be universal and not be limited by Länder, Bundes, or other level of restrictions. The exceptions, as I mentioned earlier, that are being proposed here are again on the basis of national security, of public order and safety. But there is a contested proposal here on a restriction, because it says that during processes of decision-making, information should not be shared. And of course, it's the question of protected interests of economic and financial interests, although there are other forms and laws at the international level and so on that regulate that. As you can see, Austria is finding itself in a situation where not only it has to change its political culture, within which public servants and the state has been working for decades, others say centuries, but also it has to employ institutional change. And this is important because we have new roles, new responsibilities, and new positions of contact between the citizen and the state. After this proposal was made, the OSCE issued a report on Austria, that makes the following 4 points. It makes more points, obviously, but 4 are highlighted here for the relevance, I think, and centrality in this argument of accountability, responsiveness, and openness. So the report discusses exactly the issue of administrative culture and the necessity to change administrative culture. It means that there's a requirement for the public sector to think differently about their jobs and about their service and the role of the state. And the reason is that it is possible that if the culture of secrecy doesn't change, the law will be ineffective. There is a question mark as to why secrecy is necessary during a decision-making process. It is not clear why documentation and data cannot be made available when decisions are being made and when cases are being discussed. The third point here is that there's a principle of balancing, of course, the freedom of information right to particular or protected interests. So we do not simply take for granted that protected interests will remain exempted from the law. Furthermore, which I find very interesting, is that this current proposal does not provide for access to original documents. So what is to be done, you would say? International reports and studies, this is where sometimes academics are useful, have brought together a collection of best practices from across the world. This comes from the RTI analysis of constitutional protections of the right to information. It was issued about 1.5 years ago, and it proposes certain principles for countries who are in the process of either reforming their constitutions or updating their laws. So I'm just going to go through them as you see them here. The first one is that any legal framework makes a strong statement affirming the freestanding universal right of access to all information in the hands of public authorities. The words universal and all information are very important. Universal means by anybody, and of course all information means all information. When I was working in the UK as an academic before moving to Austria, I remember very well, although we were not public servants, but working for a public institution, that all kinds of notes we had on students, for example, assessment, coursework, or on any applications for jobs and interviews, even post-it notes, we had to keep them in folders in case there was a request for information. So I remember that sometimes I didn't write exactly what I was thinking. But I was very careful of how to phrase my my critique. But this is, it has long-standing cultural effects, this kind of demand, because it makes people be more aware that they should be accountable, and I think it also makes them think twice about the opinion they would express. Of course, one other factor is the clear limits to permissible exceptions. People should know exactly what the exceptions are. They cannot be left to the judgment of any individual. Information can be withheld only if a disclosure would pose risk of or harm, and if it outweighs public interest. Another important factor is independence of oversight bodies. So when institutional reform kicks in, this new actor in public administration has to be independent. The law has to apply the principle of maximum access, so not the minimum access. which means, of course, a requirement for, as it says further down, proactive publication of information by public authorities, make data available, basically. And rapid and low-cost processing of requests. This is very important, because these are the material conditions of exercising one's rights. So it should not cost, or should cost very little, and the response should come back quickly, otherwise it is of no use. And finally, there should be sanctions for conduct that violates the right to information. That's it from me. Thank you very much for your attention.